Wayne, are you happy that I go ahead?
Please go ahead, Jenny.
Okay, thanks so much, Enos. Okay, good morning, everyone. And thanks for joining us today on the new developments this year that were introduced in the Taxation Law Amendment Act. So one of the ones that has been of interest to our industry is the changes to the immigration rules when a member is a member of a retirement annuity fund or a preservation fund. Now, as I think it was Geraldine who said, this has actually got a lot of interest in the media, sometimes even for the wrong reasons. Sometimes there have been an understanding put out by the media as to why this law has been introduced. And I think that we need to clarify in this session, in actual fact, really the background to the changes to this law. And I think that the real changes to this law were shown to us as a backdrop in the last budget review. Okay, in the last budget review, we received an intention by the legislature that they were actually going to be phasing out immigration. They basically said that from the 1st of March 2021, which is very around the corner for us now, that immigration for individuals was going to be phased out in South Africa. What were they going to substitute it with? They gave an intention that it was really going to be substituted more with a risk type of environment. Also, we're strengthening the tax treatment of externalized funds, and really more of an emphasis on ensuring that that FICA was complied with, that source of funds documentation was provided, and a proper risk verification process was installed in relation to externalized money. In relation to individuals, they were going to remove things like blocked RAND accounts, and they wanted to move towards an environment where immigrants or people who immigrated went to live in another country, and natural persons were treated identically. Okay, and then as a part of this whole process, they also alluded in the budget review to the fact that withdrawals on immigration from retirement funds would be revisited. So at the time, we didn't know exactly what they meant by that. So we had to await the Taxation Laws Amendment draft bill to see exactly what they were contemplating. And it rose from that there was so much media commentary regarding this, and doubt and basically insinuations as to what it really meant for retirement funds. Whereas I think that we've got an understanding that this is really, the changes are just part of the whole bigger immigration removal. Now, if we can go backwards and just actually look at what are we actually looking at here. We're looking at a situation where it only applies to directly retirement annuity funds and preservation funds. So both provident preservation funds and pension preservation funds. So the law initially started off only applying to retirement annuity funds, because if one is a member of a retirement annuity fund and you immigrate, you might want to take your money out and remove it from South Africa in a lump sum and not have to buy a pension in South Africa. But we all know that in a retirement annuity fund, there is no withdrawal benefit. So a law was introduced to say, okay, these people are not going to retire in South Africa. They don't have to buy a pension. So if they have officially immigrated and their immigration is recognized as a proper immigration in terms of the South African Reserve Bank rules of exchange control, then these people, these members, will be allowed to take their full money out as a withdrawal benefit. Okay, the tax considerations are completely different, will depend on where they're resident at the time. It depends on the double taxation agreement between the two different countries. but just looking at simplistically, they were allowed to take their money out as a cash lump sum. Okay, later on, we actually, as part of the industry, said, you know, we have a whole lot of people who are not, don't have to formally immigrate because they've never really become permanent residents in South Africa. They're actually temporary residents, and one day their visas are going to expire, they're going to leave the country, and they're going to not be able to get their money out of their retirement annuity funds as a cash lump sum. So we, I think we've got the wrong slides up. Yeah, that's where it is. So we then, as an industry, we lobbied to have the same thing applied to temporary residents. And the law was changed to allow it to apply to temporary residents, that when their visas expire and they've left the country, they can now apply to have their money taken offshore as a cash lump sum. Okay, and there's a whole SARS manual on this, explaining how to do it on immigration and on expiry of a temporary resident visa. Then another situation arose, and we said, you know, we've got the same problem on retirement annuity funds for people who are in preservation funds, but who have taken their one withdrawal that they're allowed before retirement. These people are also stuck in South Africa, having to buy a pension at age 55 when they are never coming back to South Africa and they should be allowed to take their lump sum. So after many years of lobbying, we actually managed to get this passed to apply to preservation fund members as well, who would otherwise be forced to buy an annuity. So that's where the situation stood. There were two tiers for preservation fund members and retirement members on immigration, and for people who had temporary resident visas when their resident visa expired. Okay, so then we needed to look at what the situation is in relation to how it affects people. Okay, so let's, as I've said to you, it applies to retirement annuity funds and preservation fund members only. Okay, it doesn't apply to members who are in a pension fund and members who are in a provident fund. Okay, now if one thinks about it logically, if you're in a pension fund and you leave the country, but you are saying have been made a paid up member, if you still have a right of withdrawal from the pension fund, you can just withdraw your money and then externalize it in terms of the normal rules, either as an investment allowance, which it would have been until changes to immigration, but you have a withdrawal benefit that you're still allowed. So it doesn't need to apply to a pension fund. The same thing with a provident fund. If you still have a right of withdrawal when you leave the country, even if you've become a paid up member, you can still take it and you don't have to use this rule. Okay, where this actually does apply, okay, is in relation to a pension fund member who has actually, where the exit event for that pension fund member is retirement. So they have become what we are colloquially calling a deferred member of the fund. If that person immigrates, okay, and they want to take their money from their retirement fund, from their pension fund, they are actually only entitled to take it as a retirement benefit from that fund. Okay, they no longer have a right of withdrawal. So those people would be stuck. But now we know, since I think it was last year or the year before, you can transfer a deferred membership benefit to a retirement annuity fund or to a preservation fund. So if one of those pension fund members who have actually been retired from employment and have become deferred members want to externalize their money in a cash lump sum, they would have to transfer to a preservation fund or a retirement annuity fund and externalize it from there, because they can never externalize it from the pension fund. Now, a provident fund member is in a slightly different position. If they don't have a withdrawal benefit any longer, as we know, up to now, a provident fund member can take their whole retirement benefit in cash. Okay, So the Provident Fund members are not as affected as pension fund members who are deferred members, because they can in any event take their full amount in cash. Okay, in time with the annuitisation provisions, it might become more relevant. They might need to also transfer to a preservation fund to get it all out, because if some parts of it are annuitised, have to be annuitised, then the landscape will change for Provident Fund members. Okay, so what actually happened on the 1st of March? And the 1st of March, well, on when the Taxation Laws Amendment draft bill emerged, we saw that what the intention of National Treasury was. So the intention was that since immigration was being phased out, you wouldn't actually be able to get your money on immigration anymore, because you wouldn't be applying for immigration. They had now substituted it with a 3-year uninterrupted period of non-residence, okay, after the 1st of March 2021. Okay, so what it looks like is that you as a non-resident, or you as a person who has immigrated, now have to be out the country as a non-resident, not just out the country, for a period of 3 years, and this takes place after the 1st of March 2021. So what did that mean? Okay, so this is where you saw a whole lot of the media commentary coming out. People were starting to say, oh, National Treasury wants to prevent people from accessing their money. Okay, and so the industry did engage with National Treasury, and we tried to get National Treasury to just allow, the minute you become a non-resident, to allow you to take your money out. Because we actually said, we raised a number of arguments. We said that people who go and live overseas, they actually need access to their money as a settling in allowance. And this 3-year rule actually creates barriers. And we asked them to reconsider the 3-year uninterrupted period of non-residence. Okay, we were not successful in that. Okay, in that SARS basically said, and they brought out their reasoning in their response document, okay, and they said that they had to take into account the difference between people actually emigrating and people leaving the country for short absences. And while they're in a period of short absence, they might be a non-resident for that period. And they said they had to, people who are away for short periods might actually come back into the country, and then they got greater rights than people who were residents and stayed the distance in South Africa for their entire lifetimes. They also said that the 3-year rule is actually a mechanism to ensure that there's a sufficient lapse of time for all immigration processes to have been completed with certainty. That's why they wanted this 3-year rule. They wanted a degree of certainty. It was really immigrating, not just leaving, staying a while, coming back, and then gets more rights than a person who is a resident. They also said that the new system will have a much lower compliance burden for those looking to move abroad. So it's actually better for people than the immigration system, and people need to acknowledge this. That 3-year rule is minimal in the whole scheme of things. And they also basically said is that just bearing in mind that this whole retirement environment is a tax incentivized environment. And government doesn't really intend a tax incentivized environment for people who immigrate. So this is really a concession. A right, it's a concession. And people need to look at this 3-year rule in that spirit. Okay, so what they did though is that another part of our representations is that we said, what about people who have already immigrated? Do they still qualify? Okay, and so National Treasury did is that they gave us a concession. They said, yes, firstly, it applies to people who have already immigrated. Their rules remain intact. But they also basically said that if you have applied for immigration status before the 1st of March to 2021, and if this has come through by the 28th of February 2022, you will also be entitled to use this concession. So your immigration has to have come through, and then in the minute your immigration has come through, you don't have to wait the 3 years. Okay, you can immediately apply to externalize your RA or your preservation funds. Okay, so that was one concession that we did get in the legislation. So now we have to look at the most of the other people, the people who would have to qualify under the 3-year non-residency rule. Okay, so firstly, what needs to be proven? Okay, the member must be able to prove. Okay, then they have to approve an uninterrupted period of 3 years of non-residency. And then who does it have to be proved to? Okay, it actually has to be proved to the administrator of the retirement fund. Okay, because the administrator is the one that actually has to process the application. They have to process the application for the lump sum. They've got to deduct the correct PAYE. They have to know if they're entitled to do this. So how do they actually, how do they get proof of this? So what has happened recently is that we have had conversations with SARS. We've had actually a meeting with industry. And we have also, we've actually put in a written submission jointly between ASISA and the IRFA, saying to SARS, all right, so we have this rule, this law that's going to be introduced from the 1st of March, but how do we implement this rule? Okay, so we've actually asked a whole lot of questions. We say, so let's say to declare non-residency to SARS. Okay, how is the member supposed to declare non-residencies to SARS in connection with this? Okay, normally one does it in the tax return, but you have to wait until the end of the year, because when does your 3 years start to run? Does it start to run from only when it's in your tax return, or can you pinpoint a point in time from which your 3 years starts to run? Okay, we wanted to know, is there some kind of special SARS form that we have to complete? What other documentary proof needs to be provided? Right now, we've got the manual on immigration, which sets out for administrators exactly what they need to get in relation to an immigration. But we don't have anything at the moment in relation to proving non-residency and non-residency for 3 years. Normally, what SARS allows us to do for DTA purposes is to prove that someone is a non-resident, is we get a certificate of non-residency from the country in which they are living, or they are now a resident. And that is normally okay for the purposes of tax directives, etc. But this certificate of non-residency just says you are non-resident now for this tax year. It doesn't show anything about a 3-year period. So how do administrators actually give effect to this? What we also wanted to know from SARS is you've got a lot of people who have been living outside South Africa for a long period of time. They technically are probably non-residents, but they've never actually declared their non-residence to SARS. From a retirement fund perspective, they hadn't officially immigrated. So they couldn't in any event get or exercise this cash withdrawal from a retirement annuity or preservation fund because they hadn't officially immigrated. So we said to SARS, there are so many people who have been living outside the country for a period exceeding 3 years. Can their period of non-residence be proven to SARS retrospectively? And if so, how? So we then said, so firstly, the person needs to establish their non-residency with SARS. Okay. Secondly, they've got to establish their non-residency for a period of 3 years. Now, satisfying it for a period of 3 years has to be to the administrator. So we said, right, now what happens with the administrator? Will SARS give the member a document which shows that they've been outside the country, they've been non-resident for 3 years? Or must the administrator request this directly from SARS? How do you prove an uninterrupted period of 3 years? What proof is required? Who must calculate it? Must the administrator calculate it, which is almost impossible, or will SARS do it? Or must the member do it? So right now, our issues in implementing this are very undecided and very vague in terms of our understanding of it. And at the meeting that we had with SARS, SARS saw the point. Mark Kingon actually realized how difficult the implementation of this is and how we need to actually develop it better. And in fact, there is an industry meeting with SARS next week, flowing from our submission to SARS, where I hope that they will give us more guidance on how to implement this. Other issues are, for example, will SARS be making changes to Form B and C? What about tax clearance procedures? Will we need additional tax clearance procedures to show that this person is a non-resident? Because normally that was done in the immigration process. Now, if the immigration process isn't there, are there other tax clearance procedures that need to take place to make sure that this person's tax affairs are in order? And the tax directive process for lump sums in the external guide, will that remain the same? So there are a whole lot of these issues from a practical point of view that we don't know how to implement. Another thing that is actually quite interesting, okay, is declaring oneself to be a non-resident. Okay, it actually has a whole lot of other tax implications. Okay, and the one tax implication is in relation to Section 9, capital H of the Income Tax Act. Okay, now this is a general law, is that when you become a non-resident in South Africa, in fact, there is a deemed disposal of all your assets, excluding immovable assets. Okay, and when you dispose of assets such as investments, there will be a capital gains tax implication. Now, the minute one declares oneself to be a non-resident, and this has been part of the reasons why people maybe have been a little reluctant to do it in the past, and now it's an issue that they're not going to be able to get their retirement fund out in cash if they don't do it, is that the minute they declare to SARS that they are a non-resident, there's a deemed disposal of all their assets from a CGT point of view, and they then have to pay CGT on those assets in South Africa. Now, the reason why there is a deemed disposal is that non-residents don't pay capital gains tax on assets in South Africa. So going forward on those assets, if they're a non-resident, they will not pay any CGT. But SARS wants to collect their CGT when they leave the country, so that when they become non-resident. The only asset where there isn't a deemed CGT is in relation to immovable property, because immovable property is the one asset where non-residents will pay capital gains tax on if they dispose of it. And so you don't have to have a deemed CGT on immovable property, because you will have an actual CGT when you dispose of that immovable property. But so the minute you do declare yourself to be a non-resident, there are tax implications. You have to pay capital gains tax on assets. And then you've still got to wait another 3 years to get your retirement fund out. So that's why we were so intent on trying to get this aligned, on the retirement fund immigration benefit aligned to happening on non-residency, because there are other tax implications which do apply. And so members do need to watch out for this and make their decisions accordingly. On the other hand, there's actually a benefit for people who are earning remuneration outside the country. All right, as you probably all know, that from the effect from 1 March 2020, residents who earn remuneration exceeding 1.25 million for services rendered outside South Africa are taxed in South Africa. But if you become a non-resident, that provision no longer applies. So on the one hand, you'll be taxed in terms of for capital gains, but on the other hand, your remuneration won't be taxed in South Africa anymore if you become a non-resident. So people need to work out their own affairs based on that. I think that it's also very important to take advice when one is exercising a cash withdrawal from a fund, the immigration benefit or the 3-year benefit. I think you need to also look at the double taxation agreements between South Africa and your country of residence. For example, you could have different tax applying whether you were in a retirement annuity fund or whether you're in a preservation fund. Okay, because just as a general guide, in a preservation fund is related to services rendered and will follow the same provisions in a double taxation agreement as services from your employer. Okay, whereas a retirement annuity fund is not linked to services. So you can actually have in different double taxation agreements, you can have a different rule in relating to RAs and preservation funds. So your RA might be subject to tax in South Africa, but your preservation fund in that same double taxation agreement might not. So it really is a good idea to take advice, tax advice on this before one actually exercises one's rights in terms of this. There is, I think it's important to note that this is really just a small piece, okay, of what is happening in the whole immigration environment. Okay, with immigration being phased out by the 31st of March, or by the 1st of March, there are other retirement planning issues around the concept of immigration, such as beneficiary nominations on a fund or sections 37C payments to people who are non-resident, or insurance policies that are paid to people who are non-resident. And we got a general guide the other day saying that this is all going to be looked at in terms of with your non-resident tax status. So the question was, for example, can we pay an insurance policy out to a non-resident? We weren't able to pay it to an offshore bank account while the immigration rules were in place. You had to have immigrated for us to be able to pay it to you outside the country. Now with the new rules, it seems like it was dependent again on your tax status, on whether you were non-resident or not. Now we are trying to get more information regarding this because we really just got a general indication of it last week. And we will keep people informed on this, especially in relation to whether you can pay Section 37C benefits to someone living outside the country or whether it has to be paid to an onshore bank account. So, yeah, we're living in interesting times in relation to immigration, in that so many of the rules have changed, and we need to, as an industry, understand how we give effect to it. So I think that's all that I've got to say in general. Happy to take questions around this. Wayne, over to you.
Thank you. Thank you, Jenny. We're actually not going to have questions today. What we'll do is we're going to have a look at all the questions raised and look at all the issues raised in the chat as well, and then try and put that, we'll put them together and provide answers to those issues raised. I just wanted to thank everyone for their participation, and we will get back to you on the further questions. Unfortunately, there's not enough time, I think, today, and I think it will probably be easier to respond to that in a written form. Thank you, everyone. I don't know if Enos wants to close the proceedings, and Geraldine quickly, and then we can log off, and we'll share the slides and the presentation, the slides and the recording later today or Monday. Thank you.
Thanks, Wayne.
Thanks, Wayne. I thank you very much to the speakers also. I don't think there's anything else for us to say other than thanks and have a good weekend.
Thank you. Thanks, everyone.
Thanks, Wayne. Cheers.
Thank you.